In January 2026, Paul Canero was tried on multiple counts of first-degree murder and aggravated arson by the state of New Jersey, which filed criminal charges following the discovery of a quadruple homicide and a series of suspicious residential fires. The charges stemmed from events on November 20th, 2018, occurring at two separate locations, his brother's mansion in Colts Neck and his own residence on Tilton Drive in Ocean Township. According to the prosecution, Mr. Canero murdered his brother's family and then set fire to both properties, allegedly staging the fire at his own home while his wife and daughters were inside to create the appearance of a coordinated attack against the family. This led to a multi-year investigation that focused on financial motives and a complex ruse theory. The case was heard in Monmouth County Superior Court before Judge Mark C. Lemieux. On the third day of the trial, Officer Brendan Bernhard of the Ocean Township Police Department, who was among the first responders to the Tilton Drive fire, was called by the prosecution. During the trial, after Officer Bernhard answered the direct examination of the assistant prosecutor, Nicole Wallace, Mr. Canero's attorney, Monica Mastalone, had the opportunity to cross-examine him.
Okay, cross.
Good afternoon, officer. So, with respect to the first conversation that you had with Mr. Canero, I just want to walk through it a little bit. So, you were told to ask Mr. Canero for this information, correct?
Correct.
Okay. And you asked Mr. Canero, where is all the DVD stuff for the cameras and everything in the house, correct? That was your question.
Where the DVR for the camera footage was.
Sir, I'm going to approach with what's been marked as S79. This is a transcript of what we just watched, okay? And you can see it's your body-worn camera. It says reviewed by Brendan Bernhard, that's you, right?
Yep.
And it has a legend here. BB is Brendan Bernhard, CW is Wenkowski, that's another officer. PC is Paul Canero, KC is Caitlin Canero, and RT is radio transmission. So here is what I was referring to, sir. At the top of page 1, you say, where is the all the DVD stuff for the cameras and everything in the house, correct?
Correct.
What you meant was the DVR, right?
Correct.
Okay. And after you ask that, between Mr. Canero and his daughter, you learn it's in the garage.
Correct.
Right, and specifically you learn it's like up to the right. You walk into the garage and it's all the way up to the right, up top to the left, correct?
Correct.
Okay. And then you ask Mr. Canero, do you have them running right now? Right?
Yes.
Okay. And Mr. Canero's response is, I've been having problems with stuff in the garage. That's his response, correct?
Correct.
So he says stuff in the garage. Problems with stuff in the garage.
Correct.
And then you repeat it back to him and you say you've been having some problems with stuff in the garage, right?
Yes.
And ultimately, so he says yes, you say okay, and then Mr. Canero says, I have a ticket open actually with one of the companies.
Yes.
Indicating some sort of IT issue.
Yes.
So, Mr. Canero, to be clear, he never says, I'm having problems with my DVR system, specifically, right?
He did not specifically say that.
He just says, I'm having problems with stuff in the garage, and there's no further clarification at that point, right?
We were talking about the DVR for the cameras, though.
Right. Well, you said DVD for you say all the DVD stuff for the cameras and everything in the house was your question, right?
Yes.
Okay. So, and then you ask if they're running, and he says, I don't know, I've been having problems with stuff in the garage, right?
That's what he said.
And so you don't ask him like, what do you mean by that, right?
No.
That's not your next question.
No.
You only have one goal at that point, which is to just learn where it is, right?
Yes.
Okay. So you're not engaging in a full-blown conversation with him, asking him to elaborate on what that meant, right?
I did not ask that.
Okay. And then You then relay, I guess it's over the radio, to Officer Marino where it's located, right? I'm at the top of the next page if you need to refresh your memory.
I believe that was to Sergeant Malone.
Oh, okay, Sergeant Malone then. So you relay over the radio where it is?
Yes.
And he said when you walk into the garage, it's to the left in the upper left corner, correct?
Correct.
And then you say, he said he's been having problems with his cameras recently, correct? That's what you say, he said.
Correct.
But Mr. Canaro never said that to you, fair?
Correct.
He never said I've been having problems with my cameras. He said stuff, right?
Correct.
And maybe that's how you interpreted it, because you were asking him about cameras, but again, there was no further elaboration or clarification. You're assuming at that point, right? You're assuming that he's having problems with his cameras when he said stuff.
I wouldn't say I was assuming. We were talking about the cameras, and he said he's been having problems with stuff in his garage, so I took it as him having problems with his cameras.
Right, that's how you took it, is my point, right?
Okay.
Yes or no, that's how you took it.
That's how I took it.
Okay.
Ms. Mastalone impeaches Officer Bernhard by pointing out the conflict between his testimony and official report, claiming the defendant stated he had problems with his cameras, and the objective body camera footage where the defendant actually states he was having problems with stuff in the garage. Impeachment is the process of challenging a witness's credibility, which can be accomplished by showing that their story has changed over time or contradicts objective evidence. Under New Jersey Rule of Evidence 803, a witness's prior statement is not excluded by the hearsay rule when the witness is testifying at a current proceeding and is subject to cross-examination, provided the statement is inconsistent with their current testimony. When these requirements are satisfied, the prior statement or the recorded interaction that contradicts the officer's subsequent written report may be used to demonstrate that the witness's recollection is unreliable, even if it is an honest mistake. Because the body camera footage captured the defendant's actual words in real time, the defense was permitted to confront Officer Bernhard with that footage to highlight the discrepancy, suggesting that the officer may have engaged in inculpatory reconstruction by putting words in the defendant's mouth to fit a specific narrative, thereby undermining his credibility before the jury.
When did this interaction with Mr. Canaro occur? How long after you arrived on scene?
I don't remember.
Was it, so this is when right prior to the officers were going to retrieve the DVR, right?
I'm not sure. As I testified, I was not really that close to the house. I was worried about scene security. The other officers were close to the house. They were out of view. I did not see them or where they were.
Okay, but you also know that they got the DVR, right?
Not that evening. I learned after the fact.
Okay. At the time when they were asking you to ask Mr. Canaro where the DVR was, you understood that to mean because they were looking for it and wanted to retrieve it. Fair?
Not fair. I asked Mr. Canaro where the DVR was just because my supervisor asked me to ask him that.
You assumed at the time that they wanted the security footage to review, right?
Objection, didn't answer.
He gave you the answer that he knows. I'm going to ask you to move on from that question.
Well, sir, you testified in a previous hearing, correct?
Correct.
In a hearing in this case.
Correct.
Right? What's been marked as D72 for identification. This is a transcript of a proceeding that you participated in back in April of this year, correct?
Correct.
Okay, I'm going to direct your attention to page 159. And this is labeled Bernhard Direct, right?
Correct.
And this is where you're sworn in. Officer Brendan Bernhard, sworn state's witness, correct?
Correct.
Okay, so this is your testimony moving forward, starting on page 159.
Correct.
Okay, now I'm going to direct your attention to page 186. I'm asking you about the security footage, right? And I say, and you didn't explain, like you said, you didn't explain why you were asking him the questions about the security footage because you didn't even know why you were asking those questions, right? And then you say, I would say that's fair to say, I mean, yeah, I wasn't entirely sure. And then you say, I assumed that they wanted security footage to view, but I didn't know why they wanted to view it exactly. Did I read that correctly?
You did.
Okay. In prior testimony, you indicated that you did assume that they wanted to look at it, right?
I also testified that the reason I asked him is because my supervisor told me to ask him.
That may be why. We can agree that that's why you asked him, correct? That's why you asked him,
Correct.
right? But the reason why the question was relevant, why you were directed to ask it, is so that the footage could be viewed, right? It's a reasonable assumption.
Judge, objection.
Officer, obviously, this conversation with Mr. Canaro happened before the DVR was retrieved, because that's the purpose of you having the conversation with him in the first place, is so that they know where to then find it, right?
Correct.
Okay.
Ms. Mastalone implied that Officer Benhard was having the conversation with Mr. Canero before they found the DVRs to establish the motives in the timeline of events, seeking to weaken the Officer Bernhard's statements with his inconsistencies. Under New Jersey Revised Statutes 2C 28-2, the statute governing false swearing, it is a crime of the fourth degree if a person makes a false statement under oath or makes two or more inconsistent statements under oath, where one is necessarily false. By acknowledging on the stand that he assumed his superiors wanted to see the film, Officer Bernhard confirms what he was denying earlier in his testimony. Under New Jersey law, the state would need to prove that the witness did not believe the statement to be true at the time it was made. However, even though Officer Bernhard's testimony reveals a stark contradiction between his 2018 radio report and the actual 2018 events, he will probably not face prosecution for false swearing or perjury. This is largely due to the concept of prosecutorial discretion and the difficulty of proving materiality in a perjury context. In the context of police testimony, such discrepancies are typically characterized as failures of recollection or unintentional errors occurring during high-stress investigations. While this admission allowed the defense to portray Officer Bernhard as a witness with tunnel vision who manufactured a justification for a warrantless seizure, the lack of evidence regarding a willful intent to deceive serves as a practical shield against criminal liability. Therefore, while the impeachment served to dismantle the officer's credibility before the jury, the legal threshold for a perjury charge remains a significantly higher hurdle than merely proving a factual inconsistency.
Your report was not, you authored a report in this case?
I did.
It was not provided to the prosecutor until last year in 2025, correct?
Objection.
What's the relevance of the date of his report?
The fact that it was provided 7 years later, and and the reason is a Spillman reason, which
Okay,
is relevant.
go ahead.
That's correct.
Okay. And so the reason why your report wasn't provided until 7 years later is because at the time that you wrote the report, you weren't able to enter into Spillman. Is that correct?
I wasn't able to enter into that particular call in Spillman.
Okay. And and when did you, tell me if I'm wrong, at the time that you tried to enter your report, you were trying to write it directly into Spillman, correct?
Correct.
And just so the jurors are aware, what is Spillman?
Spillman is the police database that my police department uses, which we write reports on, and there's a lot of police data on it, confidential police data on it, and that's where we write our police reports on.
Okay. And when did you write your report originally?
I'd like to clarify, I believe I previously testified that it was estimated a day or two after the call for service.
Right.
A more accurate depiction would be between November 20th and November 29th.
Okay. So somewhere in a 9-day time period is what you're saying?
Correct.
So originally you thought maybe it was a day or two, now you're saying it could be a little more than a week.
Correct.
You're not sure when.
The report was saved to when Spillman was locked and I could not access it. I wrote the report on a Word document and saved it to my police file on our police department computer. That file was last edited on November 29th.
Okay.
2020.
All right, so at that time, when you attempted to put it into Spillman, Spillman was locked, meaning you could no longer enter your report into Spillman.
Correct.
And that's because the call or the case was closed at that point, is what you're saying?
The Spillman case was locked,
Okay, and well, why would it be locked?
so no reports could be added or deleted.
And does that normally happen when the case is concluded?
I mean, in my opinion, the case is still active. I guess if the investigation is concluded, if that's what you...
Well, like, who decides when to lock Spillman?
Objection.
I'm not sure.
He doesn't know.
So, in your report, you discuss your role on the 20th, correct?
Correct.
And at the end of your report, you write NFAT, which stands for no further action taken?
Correct.
Okay, but there was further action taken because, as you just testified, you actually transported Mr. Canaro that night, correct?
Correct.
And that was, it was the same day, but it was later that evening,
Correct.
maybe going into the next day, but like around midnight or so?
I don't remember the exact time, but yes, later that evening.
Okay, and you didn't memorialize anything about that in your report, correct?
No.
Nothing further, thank you.
Ms. Mastalone asked Officer Bernhard whether the 6-year delay in generating his supplemental report constituted a violation of standard operating procedures, prompting a rigorous cross-examination regarding the reliability of the officer's memory under the Sixth Amendment's right to a fair trial. Officer Bernhard testified that he did not provide the formal report until 2025, a delay he attributed to the administrative technicalities of the Spillman Records Management System. The Spillman system serves as the digital infrastructure for the department's documentation. Under these protocols, an officer's reporting duties are often dictated by the status assigned to an incident file. Officer Bernhard explained that because the local police response was designated as no further action taken, known as ONFAT, he operated under the assumption that his primary reporting obligations had been fulfilled. Accordingly, Ms. Mastalone highlighted these discrepancies to imply that a report generated years after the fact, regardless of the Spillman reason, may lack the evidentiary weight of a contemporaneous record, especially after Officer Bernhard confirms that he was the one who transported Mr. Canaro the night of the fire, showing that had further action taken, even if they filed that there was none. On February 13, 2026, Paul Canaro was convicted of 15 charges. These included 4 counts of first-degree murder, as well as aggravated arson, possession of a weapon for an unlawful purpose, and misusing property that had been entrusted to him. Paul Canaro is set to be sentenced on May 12, 2026. Our next case occurred on March 1, 2011, when defendant Jamie Jordan stood evidentiary hearing in Oakland County, Michigan, on charges of open intoxicants in violation of Michigan Legislature 257.624 and possession of a forged or altered license in violation of Michigan Legislature 257.257. The charges stemmed from events that occurred on May 6, 2008, when Trooper Kaiser of the Michigan State Police stopped Mr. Jordan for speeding. Trooper Kaiser initiated contact with Mr. Jordan and allegedly saw an open intoxicant in the car, which led to a probable cause to search the rest of the vehicle and Mr. Jordan for more illegal items. Trooper Kaiser testified that he became suspicious of the defendant's driver's license, citing a discrepancy between the issue date and the defendant's apparent age. Furthermore, while the defendant admitted to having prior citations, the trooper was unable to locate a matching record in the law enforcement information network system. During a search of the defendant's pockets, Trooper Kaiser recovered several credit cards in the name of Mark Johnson, along with one in the name of Jamie Jordan, leading to the defendant's arrest. The case was heard in Sixth Circuit Court in front of Judge Edward Sosnick. On March 1, 2011, Trooper Kaiser was called by the prosecution. After Trooper Kaiser finished the direct examination of the prosecutor Rick Polanco, defense attorney Neil Rockand had the opportunity to cross-examine him.
Okay?
Absolutely.
All right. You're a state trooper,
That's correct.
and this Michigan State Police has policies, correct?
Yes, sir.
Okay. And those policies are called official orders, are they not?
Some of them are, yes, sir.
And they're assigned numbers, correct?
Some of them are, that's correct.
For example, there could be an order number 1 or order number 5, right?
That's correct.
All right. Order number 87, Have you heard that number before?
Yes, I've heard 87 before.
Have you heard order number 87 before?
Not by number, I couldn't reference it.
Would you agree with me that, let me see if this language, if you've heard this before in your experience, okay? Let me back up 1 second. The Michigan State Police has policies about preserving and collecting evidence, true?
Yes, sir.
The evidence collected has to be collected, cataloged, or indexed, correct?
Correct?
Evidence can be photographed, correct?
It can be.
Okay. And let me ask you, the Michigan State Police has a policy that says certain procedures shall be followed in order to ensure that a proper record is maintained of all property or evidence. Is that true?
Yes, sir.
Okay. Your Honor, I don't think there's any objection by the people who have already to the admission of Defendant's Exhibit A, which is Official Order Michigan State Police Policy Order Number 87. So I would move at this time to have Defendant's Exhibit A admitted. Unless, it's okay. If I misunderstood the stipulation, that's fine. If I did, then I'll question about it.
I'll stipulate that document. I don't know if it's an official, I don't have personal knowledge that's an official order, but I stipulate the admission of that document, sure.
I'd not receive it.
Okay. And there's Defendant's Exhibit A. Now, you testified that, what policy number, we'll strike that, the Michigan State Police, you haven't produced, and tell me if I'm wrong, an actual written policy that says that in OWI or open intoxicant cases, that you should dump out the contents of the bottle and or not actually catalog or preserve the bottle. Is that true?
You're asking if I've produced a
Yes.
document?
Yes.
I have not produced a document.
Okay. Is there such a document?
I am not sure, to be honest.
How did you get the order to process open intoxicants by pouring it out and giving the container back?
Judge, it's my contention that there is no such order.
I'm just saying,
I understand.
I mean, obviously you don't see an order here, but how did you learn to do that, and who told you to do that?
Because order number 87 says that, and if I could just intercede, Judge, order number 87 says, if you look at the exhibit and you look at page 1 and page 2, it says the following procedures shall be followed in order to ensure that a proper record is maintained of all property. Evidence taken after 1/1/1999 shall be identified by attaching an exhibit label generated by the department's records management system. Not identified, and there's a sticker, obviously. And then evidence that received, transferred, removed, replaced, or disposed of the property segment shall be updated. The importance to the accused in the case is that he has the right to challenge or contest evidence later on in court. You understand that?
I do understand that.
And that the location of the bottle, for example, is an issue in an open intoxicant case, correct? It can be.
It can be.
In other words, was it in the trunk or was it in the interior passenger compartment of the car, right?
That would be
Okay.
a factor.
One way to actually preserve the location of the evidence would be to actually take a photograph of it, where you observed it, true?
That is one way, yes.
Okay. Another would be to bring over an eyewitness, for example. Could be some passerby, could even be another backup officer, true?
It could be, sure.
Another could be to actually have, to leave the evidence where you observed it, and when a tow operator comes, have the tow operator inventory the item where you observed it, true?
It is possible, yes.
Okay. In the Michigan State Police policy, order number 87, can we agree that that's the only written policy that you could produce that describes what to do with evidence of a crime? Can we agree with that?
Readily produce, yes.
But do you mean that if we took a break, for example, that you could show up here if the judge instructed you to in the afternoon or the next day with some policy that says you were taught that it's appropriate to dispose of either the contents of a bottle or a bottle itself that could be evidence in a case? Are you saying that you could produce that?
I don't know if I could, sir.
Okay.
During cross-examination, Mr. Rockin challenged Trooper Kaiser's handling of physical evidence by referencing the department's own mandatory protocols. Mr. Rockin directed Trooper Kaiser's attention to Michigan State Police Official Order 87, the authoritative manual on evidence and property management, which dictates the strict procedures officers must follow to ensure the integrity of a scene. By establishing that there is no written policy within Order 87 or any other training material, Mr. Rockin highlighted a significant departure from professional standards, and the destruction of the liquid constitutes spoliation of evidence. This line of questioning served to undermine the reliability of the entire investigation, suggesting that Trooper Kaiser either failed to account for documented evidence handling requirements or chose to disregard them.
And so you take the license and you actually go back to your car, and I'm going to talk about your discussion with Mr. Jordan, but you go back to your car to run his name through Lean and or through the Secretary of State computer system, correct?
Yes, sir.
Now, as you're doing this, understand that all you possess in your hand is this driver's license, right?
Yes, sir.
You had asked him some questions about his driving record, right?
Yes, sir.
He said he had a couple of tickets in the past, true?
Yes.
You didn't ask him what specific types of tickets they were, is that true?
That is correct.
You didn't ask him where those tickets were, like in what court, for example, is that true?
That is correct.
And you didn't ask him how those tickets were disposed of, in other words, whether they resulted in conviction, dismissal, or resulted in some non-abstractable offense, correct?
That is correct.
Let's talk about how tickets can be resolved. In your experience, in your 15 years, you know that you can issue a civil infraction ticket for an individual, right?
Yes, sir.
The civil infraction ticket itself the person would have to go to court to typically contest that ticket, is that right?
Typically.
Okay, well, let's talk about the cases where they don't. It could be, for example, a waivable offense. A waivable offense is what? Like defective equipment, or could be no registration, or no proof of insurance, something like that, correct?
No proof of insurance is no longer waivable.
Okay.
But
Tell the judge what a waivable ticket is.
it's a ticket in which the defendant can take to a police authority to sign off on the ticket, mail that ticket into the court, and it gets waived or canceled.
Okay. In other words, Mr. Jordan told you that he had a ticket, right, in his past?
Yes, he did.
You did not know at that time whether it was a waivable ticket or whether it was a non-waivable ticket for which he'd have to go to court. True?
That's correct.
And can we agree that you didn't investigate that?
At that time, no, I did not.
Can we agree that you assumed the worst when you heard the word ticket, that you heard or thought that it was like speeding or something, that you assumed the worst at that point?
I don't know that I characterize it as worst, but
But you assumed that it was, you assumed something. You jumped to a conclusion about what the word ticket meant, right?
I was asking him about his record.
I understand.
So if he
It's pretty clear in your mind that what you weren't referring, that you didn't leave room for the option at that point that he was saying ticket could have been a waivable ticket or something of that. You didn't think that at that time. You weren't thinking that way, were you?
If you'll allow me to answer the first part of your question.
I just wanna know whether
you
you-
offer your next statement as you're
Let
doing,
him
counsel.
answer.
Go ahead.
All right. When I asked him about his record, I'm assuming that that meant a ticket on record, meaning some type of conviction, not a ticket that was disposed of, or it wouldn't be on his record. So I asked him about his record. He said he had a couple of tickets.
You know that when I interview clients and I ask them if they have anything on their record, they always say that too, that they have had a couple of traffic tickets. Sometimes those don't show up on records. You'd agree with that, right?
Sometimes, yes.
A truthful answer, the most honest answer a person could give you about whether or not they had anything on their record, if they didn't know if it was there or not, would be to tell you they had a couple tickets in their past. Is that true? That'd be the most truthful answer, wouldn't it?
I don't know about it being the most truthful, sir. That would be speculative.
Okay. And a non-abstractable offense would mean that even though the person received the ticket, it wouldn't show up on their record.
That's correct.
If I can just maybe speed things along, I can stipulate to the fact that sometimes tickets are not abstracted. They don't appear on record. I have no objection to that.
I appreciate that, and I think we all know that. I'm just trying to make the record bear out that when you ran his record, on the Secretary of State, you concluded, you said to the judge that that was a big inconsistency in your mind, right?
I felt that that was further suspicion being an inconsistency.
Even though it could be entirely consistent with a person having had a couple of tickets, as he disclosed to you, and having no record. In other words, person receiving non-abstractable or waivable tickets, correct?
If that were the sole thing I was looking at, that would be correct.
Mr. Rockand impeached Trooper Kaiser by exposing a critical discrepancy regarding the defendant's driver record and the trooper's justification for the arrest. While the trooper initially testified that the defendant's license status necessitated a custodial arrest, Mr. Rockand confronted him with the reality of the Secretary of State records, which indicated the status was not as severe as portrayed. Under Michigan Rule of Evidence 613, a witness may be impeached by showing that their testimony is inconsistent with the facts or prior representations. By establishing that the trooper's account of the license status was inaccurate, Mr. Rockand suggested that the trooper used the record as a pretextual basis for a deeper investigation. Furthermore, Mr. Rookkind highlighted an inconsistency in the trooper's exercise of police discretion regarding the issuance of a waivable ticket. He established that the alleged offense was a civil infraction, which typically allows a defendant to provide proof of compliance to have the citation dismissed. However, Trooper Kaiser bypassed this standard procedure in favor of a full custodial arrest and search. This choice serves as evidence of an ulterior motive, as it demonstrates an inconsistency between the trooper's training and departmental policy and his actions at the scene. This line of questioning suggests the arrest was not a matter of public safety, but a strategic maneuver to bypass Fourth Amendment protections.
All right. You told the judge that an important factor in consideration was that the license had been issued, best of your recollection, within 6 months of the incident date. Do you remember that?
My recollection was that
I
that's
understand.
correct, and
Okay.
I misspoke.
Right. The license actually had been issued December 2nd, 2004. Is that right?
Yes, sir.
Okay. And even though it was in its first cycle of the license, you would agree that the probationary period for that license, when you stopped Mr. Jordan on May 6th of 2008, had ended. Isn't that true? Probationary period does not last 4 years, does it?
No, sir, but the license had not been renewed.
I understand that.
That's,
I'm saying, though, that it was not in the, quote, probationary period. Would you agree with that?
Let me refresh myself. I don't believe you'll have the lien work in here, counsel. I may have to obtain that from the prosecutor, reference the probationary status.
It's not. It really isn't that major of a point, Judge. It's just, if he wants to dig for it and give it to us later, it's fine. My point was that the license was 4 years old, as opposed to.
It had not been renewed.
I understand.
It was an original license. I did misspeak on the particular time frame that it had been in existence.
Okay. And if you could share with me, Trooper, this card. You said you searched through his pockets after he was placed under arrest. Is that right?
I did?
And you searched through his wallet, I believe. Is that right?
Yes, sir.
And you told the judge that you found some cards or credit cards in the name of Mark Johnson. Is that right?
Correct?
And you found one card that had the name Jamie Jordan on it, right?
That is correct.
And could you show us in the discovery where that card that had the name Jamie Jordan is? Did you take a photograph of it or a copy of it or preserve it in evidence?
No, sir.
Did you save that piece of evidence at all?
No, sir. I didn't feel it was evidence.
Okay.
Mr. Rockand scrutinized the trooper's handling of the physical cards found in the defendant's pocket during the search. While the trooper was diligent in documenting several cards in the name of Mark Johnson to support a theory of identity fraud, he admitted to also discovering a card bearing the defendant's actual name, Jamie Jordan. Mr. Rockand highlighted that, despite the trooper's focus on the defendant's identity, he did not preserve, photograph, or photocopy the card bearing the name Jamie Jordan as a piece of evidence. This line of questioning served to undermine the integrity of the state's investigation, suggesting a significant degree of investigative bias. By eliciting the trooper's admission that he didn't feel the card with the defendant's true name was evidence, Mr. Rockand laid the groundwork for an argument that the police selectively preserved only incriminating information while disregarding exculpatory facts.
In other words, the objective information that you got from your lien run was that this man with this license and this name was allowed to drive in the state of Michigan on this date, correct?
That's what a fraudulent obtained license
Hold on,
is.
I didn't ask you that. I just want you to answer my question. I know what you want to tell Mr. Polanco. Just answer mine, okay? The actual Secretary of State lien run that you showed was that he was lawfully allowed to drive, correct?
Under that identity, yes.
Okay. And once you ran all this stuff on the computer, you returned to the police car, or to his, excuse me, to the Mr. Jordan's car, and you engaged him in no colloquy, no discussion. Isn't that right?
Essentially, that's correct.
You didn't ask him any questions about any of that.
That is
You
correct.
just arrested him.
That's correct.
So the entire investigation arrest sequence lasted approximately 4 to 5 minutes, true?
Ballpark.
And it's at that point that Mr. Jordan was removed from the car. You began your arrest or detention procedure, correct?
Correct.
Would you agree with me that at that point, Mr. Jordan was not free to leave, that he was being detained by you?
That's why he was in handcuffs.
Okay. What you just said about how long it took and what you did with Mr. Jordan, that's not entirely true, is it, Trooper Kaiser?
I don't understand your question.
Well, when you returned to Mr. Jordan's car from having done your lien run, you actually started to, you swore at him, didn't you?
No, sir.
Didn't you say to him, who the F are you?
No, sir.
Didn't you press him about what he was doing and you wanted to get to the bottom of it and you were going to? Didn't you do that?
Judge, if I can, I think this is outside the scope of my redirect. I mean, this is basically holding my cross.
You know what?
There's,
It may be true. I have discretion. I want to get, let's get all the facts out. This is really the whole key to this situation, okay?
Your Honor.
isn't it a fact that you actually continued to press Mr. Jordan about details and whatnot for approximately 45 minutes from the time that you stopped him until you actually made the decision to arrest him and to call for a tow? Isn't that true?
Absolutely not.
Okay. You called for a tow, would you not agree, and I mean a tow, like your decision to impound his car, you did do that, didn't you?
Yes, sir.
And you made the decision there was no one there to take over his vehicle once you arrested him, correct?
I would have stood by for the tow truck, but
I understand.
Trooper Millhouse arrived.
Okay. Have you looked at the report, by the way, to answer the question I asked before about Trooper Millhouse?
No, you've been kind of long-winded, counsel. I haven't had an opportunity. Give me a moment.
Sure. You can berate me, and it's okay by me, no problem.
No one's ever said that about you.
No, they haven't. Well, it won't be the first time. I also have, won't be the last. Won't be the last time that this won't be the last time that I've also cross-examined a police officer who has wit and charm.
That's a compliment, Trooper.
Thank you.
Not from me, from him.
That's how it was Davenport.
Would you, Mr. Polanco was looking for the document where you referenced Trooper Millhouse as your backup officer. I anticipate the forthcoming concession.
I already conceded.
Yeah, it doesn't, it's not there, is
I
it?
misspoke about a different trooper, sorry. I apologize.
You completely omitted her from your report, isn't that true?
Structurally, yes, sir.
Okay. I have no clue what that means structurally. Do you mean that you didn't mention that the Burnett and Millhouse actually played an official role in this case in some capacity or other? Is that what you mean by that?
She played no part in the arrest sequence and criminal proceeding of this case.
I just want to know whether or not, you said structurally, do you mean that in the entire body of this police report that you did not reference Trooper Millhouse having played any role?
She should be listed on the vehicle form, but I'm not seeing it in the stack of documents you gave me.
Is there some, I want to be clear that I've given you a packet that contains an investigation that spanned what looks like a couple of years.
Yes, sir. I don't see the document in there.
Trooper Millhouse, you didn't even reference that you even had a backup officer that day, isn't that true?
I'm sure I mentioned it in our prior court proceedings, but I did in our report, sir.
I know, just because I questioned you about it. I'm talking about, you know that I'm talking about what you wrote in your report, not what you're answering to my questions. I just want to know, would you concur that her, either that or Mr. Polanco, would you concur that she's omitted entirely from your report?
As I've said, I don't see her memorialized in the report.
Okay. And if you arrested Mr. Jordan within 4 minutes or 5 minutes of your having stopped him, which is what you testified to, you didn't call for backup or for a tow operator to come do anything with his car until what looks like about 10:30 or so. Do you dispute that?
No, I wouldn't dispute that.
So you actually had this man alone at the scene with just you. You're saying he was under arrest for about 45 minutes or so from the time. Is that right?
Including the time I stopped him, our conversation, computer checks, searching the vehicle prior to impounding it, and requesting a hook. That was probably about 40 minutes.
Well, the policy, actually, the state police policy about searching the vehicle pursuant to impound is that you actually have to have the impound operator actually sign off on the contents of the vehicle. Isn't that true?
Yes, sir.
Okay. Well, you just said you searched the vehicle before you even called for impound.
That's right.
So you did the search without even having the person who's going to take the car actually even look through the contents to verify that what you say you found is what you found. True? Is that true?
Please rephrase that.
You say that during the 45 minutes or so that you searched through this car, that you did it without the impound or tow operator even being there.
That's correct.
So you couldn't have followed the state police policy which says that you're supposed to have the tow operator actually observe what it is that you found during the search of the car so that the accused belongings can be properly chronicled. Correct?
That is incorrect.
Okay, so you have Mr. Jordan, you said, and during that 40 minutes or so, from the time that he was arrested until the time that you called for this tow company to come, you're saying you didn't ask him any questions at all. You didn't berate him. You didn't press him about who he was.
I was busy searching the car. Upon arrest, he was inquiring to me what this was all about, and I told him I did not believe the identity he provided was true, and I placed him in my patrol car.
Where is that in your police report? Where is that colloquy in your report, Trooper? Where's any of that? Go ahead, you got the whole report there. Look through it. Find the spot where you said that he questioned you about that and you engaged in that colloquy.
Sir, it wasn't a question to him, nor a response to one of my questions. So
I understand
didn't
that, but you didn't.
put that
This
in.
is a statement by an accused. You're claiming he made a statement to you at the scene. Where is that statement referenced in your report? Would you agree that it's not?
Absolutely, it is not.
Defiantly that it's not. You know it's not.
Correct.
So you have an accused that's asking you questions about reasons why he's being stopped, and you just omit that entirely.
You can ask it 10 different times, counsel. The answer is going to be
Okay.
no.
Now, you testified that as you were in this discussion with Mr. Jordan, where you had going through the belongings in his wallet and whatnot, and you hold up this Sam's Club card, that you say that took place in your patrol car.
Correct?
You know, I thought we're limiting this.
We are.
frankly, to the basis for the arrest.
I did too, Your Honor.
Yeah, okay.
We are, Judge.
He annoys me sometimes, too.
He must get paid by the word, Your Honor.
You know what's interesting is I thought the same thing about you, Trooper
No,
Kaiser.
it's
I thought you got paid by the word.
Call it quits, okay. It's enough.
Would you just, and I'm just going to hand you what we've previously marked as Defendant's Exhibit E, just to corroborate what I said about the tow records and when the tow truck was called. Have you seen those before?
No, sir.
Is that the tow company that you called?
It appears to be.
That the tow company that responded?
I have no independent knowledge of their records or process keeping, so it's paperwork with their name on it. It's all I can tell you.
Okay. I don't know, Judge, I'm going to move for its admission under 104B. I don't know if Mr. Polanco has an objection, otherwise, we've attempted,
What's the relevance?
it's just to show how long when the trooper actually called for a record, it shows 10:30. I don't
No, but
know.
it's, again, it's,
I understand.
it might be, credibility or whatever it is, but we're really down to, you've got a traffic stop. You've got, you're not gonna argue that you shouldn't ask for a license. He gets a license, it appears to be a valid license, he's got suspicions because of the age, and his special knowledge of when it would have been, that would have been the first license issued to that person. He went to the car, ran a lien, he didn't see, that he was, just got out of jail or prison, or anything from another state, and that when he asked him, have you had any prior, traffic, he said he had a couple tickets, but couldn't say when. That's basically all the facts that you have to determine what didn't happen.
I understand.
In other words, from a legal standpoint.
I don't have any
And
other
I
questions.
really have no idea whether at the moment that's enough for probable cause. Any other questions?
No.
All right, thanks, Dr. Green, all set.
Mr. Rockand challenged the legitimacy of the arrest by highlighting the stark contradictions between the trooper's courtroom testimony and the omissions recorded in his official police report. First, Mr. Rockand established that the integrity of the investigation was further undermined by the trooper's omission of a second officer from his written report. Professional police standards require a full and accurate accounting of all law enforcement personnel present at a scene to ensure transparency and allow for the verification of facts. By establishing that the trooper entirely deleted the presence of another Michigan State police officer from his narrative, Mr. Rockand utilized impeachment by omission, arguing that the report was not a neutral record, but a curated narrative designed to insulate the trooper's version of events from potential contradiction. Furthermore, Mr. Rockand targeted the complete lack of data and timestamps regarding the time of the arrest and the arrival of support vehicles, such as the impound car. Standardized reporting requires precise timing to validate the constitutionality of a detention. By demonstrating a failure to record these critical time markers, Mr. Rockand argued that the report failed the trustworthiness requirement of Michigan Rule of Evidence 803. Ultimately, Mr. Rockand, the trooper, had predetermined his intent to arrest the driver long before any alleged violation occurred, rendering the subsequent police report a mere formality and an unreliable backfilling of facts rather than a legitimate investigative tool. This bad procedure suggested that the trooper's testimony was based on a reconstructed memory tailored for conviction rather than the objective reality of the encounter. On the same day, the court dismissed all the charges against Mr. Jordan. These cases demonstrate how important the determination of a trial is by the testimony of police officers and how far the defense can go to test this trustworthiness. Throughout their cross-examinations, both defense counsel drew the judges' and jurors' attention to numerous contradictions and errors in the officers' accounts, underscoring the significance of proper police protocol and evidentiary grounds for an investigation. These encompass discrepancies regarding how certain incidents unfolded and uncertainty over whether additional officers had been present at the location. By exposing these divergences between the officers' prior statements and their in-court testimony, the defense attorneys convinced the jury that the narratives were untrustworthy. Even though the first case ended up with a guilty verdict, officers must tell the truth to keep the trustworthiness of the public on law enforcement. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help promote a more informed society.